Welcome to another installment of Church and State with Chris Farrar and Brian McCall. We have two interesting stories that involve leaks of documents to talk about this week. How are you doing, Chris? Things been well with you this Easter season?
Yeah, but it seems that the world is falling to pieces at an ever-accelerating rate. Total breakdown in law, collapse of the institutions, and the leak from the Supreme Court will be something we'll talk about in that regard.
Yes. So first, let's start with the church, and this story's been evolving since Lent. So it was began to be reported during Lent that a memo has been circulating around the College of Cardinals and within the Vatican by someone who only identifies himself as Demos, which in Greek means people. And it's a scathing indictment of the entire pontificate on almost every level of Pope Francis, Jorge Maria Bergoglio. It's on the level of doctrine, the level of praxis, theology, politics, financial, and just really as an indictment on many levels, and a plea that the next pope needs to get the church back in order. And I'll just read a couple of the, again, I call them indictments, that he says. He basically says is, the whole pontificate, the whole church is off track. He said previously it was Roma locuta causa finita est. Today it is Roma locuta confusio augetur. So rather than Rome is spoken, the cause is finished, confusion is spread. And much of that confusion, he cites the German synod, speaks on homosexuality, women priests. We get silence is emphasized when contrasted with the active persecution of traditionalists and contemplative religious orders. There's no longer a Christocentricity to the church. Pachamama, idolatrous. I mean, Amoris Laetitia is mentioned. The financial scandal with Cardinal Becciu, who they're basically saying is a scapegoat who's taking the fall. That the Pope and the church is completely ignored on political levels, for just as basically irrelevant. And again, as I said, it's one of the most scathing condemnations, which some legitimate journalists, including Sandra Magister, have published this and have vouched that it appears to be authentic. So what do you make of this circulating in the Vatican, and what do you think it means for the church?
Well, the phrase circulating in the Vatican is very telling because according to the article I'm reading from the Society website, this document was found at the bedside tables of the cardinals.
Yes.
Meaning someone very highly placed in the Vatican is circulating this document among the Vatican cardinals, indicating that this is a revolt within at the highest levels of the Vatican bureaucracy. I find that considerably telling because normally a document like this, it might be published on the internet and you might be reading it as an internet document, but this was actually delivered to the cardinals from within. So that indicates a recognition inside the Vatican itself that this pontificate is indeed a catastrophe. And I note that the article on the Society website says that the author is not being subtle, but I don't think subtlety is called for.
Right.
I think this pontificate is exactly what Demos says, a catastrophe. It's obviously so. And in terms of the attack on traditionalists, well, that's the culmination of a process that's gone on for nearly 60 years now, the essence of which is an attack on traditionalists. Beginning with the deformation, which they call a reformation of the liturgy. It's been that way for 60 years. And there was a partial liberation under Benedict XVI, but now there's been a retrenchment under this pontificate, this catastrophic pontificate. And now the attack on traditionalists has never been more explicit. His entire pontificate thematically condemns traditionalists as being rigid and pharisaical and attached to the past and stubborn and unable to recognize the wind of the Holy Ghost, which blows where it will and so forth. But this Pope is, in fact, the most rigid Pope we've seen in our lifetimes. An absolutely inflexible ideologue. But there's a paradox here, because even though that's what he is programmatically, he's also something of a politician. So when a couple of priests of the priestly fraternity managed to get an audience with him and were able to schmooze him for a while in the manner of a politician, he basically told them what they wanted to hear and gave them what they wanted, which was that decree saying that the fraternity, the priestly fraternity, and by implication all the other apostolic societies attached to the traditional rite, is not bound by Traditionis Custodes. So he's a bit of a self-contradiction in that respect. And if you get to him on a personal level, he might respond to you to make you happy, to tell you what you want to hear. But there's no question that his program relentlessly moves in the same direction, ever leftward during the still ongoing post-conciliar revolution.
No, it's interesting you mentioned that apparent contradiction, because my family and I were talking about the film The Godfather a while ago, and as I thought about it, it almost like that's his governing style is, the Marlon Brando character, Mr. Corleone, right, who is sort of utterly corrupt in principles, will murder, do whatever, but on the personal level, if he sees an opportunity to do a favor for someone that he can call in later, he'll do that, and it almost, that seems like how the church is being governed, by a godfather figure.
That reminds me of a joke someone told me about that famous scene from the movie where the Godfather says, after having promised the favor, "Someday I may ask a favor of you. That day may never come, but it probably will."
It probably will. Well, and again, with the priestly fraternity, the February decree you mentioned, that day may have come, because it was also reported in the past week in another one of these private meetings, no published report, with the head of the French Bishop Conference. Pope Francis says to the head of the French bishop, "Oh yeah, the priestly fraternity, who I told were exempt from all this, they have to concelebrate at the Chrism Mass, by the way."
Yeah.
And again, so it's all backdoor between us deals that are never confirmed, never made public. But again, well, I made them happy by telling them that. I'm going to make you happy by saying you can crack down on them.
Well, at least we can say that the idea that they must concelebrate has not been reduced to any kind of formal decree, whereas the fraternity managed to extract an actual written instrument confirming that they're not subject to Traditionis Custodes. Although there's a back door on that.
Yes.
To the extent possible, the same document says the norms of Traditionis should be applied. So,
right. Well, it is, as I think you're right, chaos is really the word that jumps out of this memo, this chaos in the church. So, but what does this mean about if the cardinals are reading this? I mean, what do you think they're already planning the next conclave, essentially? Is that what this is a sign? They think this is winding down, this pontificate?
Well, it has to be, just as a matter of statistical inevitability. How old is he now? 84?
80. Yeah.
No, he's older than 80, I think. I think he's 82 or 83.
Yeah.
He's got some serious issues with the surgery on his colon, which could well be cancer. You know how the Vatican tends to hide the health status of the Pope. Mm-hmm. He can't even walk now because his knee is completely shot, so he's not able to walk around. So it's just a matter of time. They're obviously getting ready for the next conclave. But then the question is, what will that conclave produce? If the Holy Ghost is truly involved, it would require a miracle of grace brought about by the influence of the Holy Ghost to get anything from that conclave that would even approach a restorative papacy like that of Benedict XVI. So we'll have to see, because during his pontificate, Francis has managed to stack the College of Cardinals with a bunch of, forgive me for using such a crude term, dinglings, modernist dinglings. And God help us if Cardinal Tagle, I hope I'm pronouncing his name correctly, from the Philippines, becomes the next pope. And you've seen pictures of him, getting down with the young people and dancing like a fool. Mm-hmm. If that's the next pope, we might even be in a worse situation than we are now. But humanly speaking, we don't see any way that the next conclave is going to produce any pope who's intent on restoring the church. But again, miracles happen at conclaves. So
miracles happen, and again, we don't know. There may be, as in most revolutions, there is the hardcore, party members who will do anything for the revolution. There's the sort of hardcore counter-revolutionaries, but then there's usually a vast, majority of company men in the middle who sort of want to see where the wind's blowing, who are, and I'm sure the College of Cardinals, if he stacked it, is not all that different. There's probably, a lot of people who are just in the middle, and maybe are willing to say, you know what, this, even if they're not on the right side, say, well, this has gone a little too far here. We need brakes on this, and maybe God will use that to surprise everyone. We don't know.
Well, yeah, it's the old distinction between the Bolsheviks and the Mensheviks. So the Bolsheviks say, burn it all down, kill them all. And the Mensheviks say, not so fast.
Yes.
So they might slow things down a bit. But I think at best we have some Mensheviks.
Yes.
In the College of Cardinals. Oh, there's still some conservatives, probably about 10% of them. So we'll just have to see. And compromises happen in these conclaves. So you could end up with a compromise candidate. And that compromise candidate, if he's validly elected, would have the grace of the office, and he could change his mind. Consider the historical example of Pius IX, a liberalist who barely escaped death at the hands of Masonic assassins, fled from the Vatican disguised as a simple priest. And after that, his liberalism was over with. He realized what he was confronting, which was radical evil. And he became the most anti-modern pope in church history, giving us the syllabus of error. So that could happen with any pope. And it may happen with the next pope. Maybe the next pope will be in a situation where he barely escapes assassination by a mob. Look what's happening in the United States. The left has decided that the way to get what it wants is basically to destroy things, burn things down, threaten people's lives. They just doxed the names and addresses, the addresses of the 6 conservative Supreme Court justices. They've been published now on the internet, so that left-wing fanatics can go to their homes and threaten them. So, we may find a pope in that situation very soon.
Well, speaking of that and changing our minds, that brings us to our story here at home. Really, an incredible story, a draft opinion authored in draft form by Justice Samuel Alito, who was appointed by George W. Bush to the court, on the Dobbs case, which is the case that is reviewing the constitutionality of a 15-week gestational abortion ban. So no abortions after 15 weeks. The 98, I think it is, page opinion was in draft form as of February and indicates a majority of the court voted for this result, and that Alito was drafting an opinion. Now, I mean, before we get into the details of what we learned from it, I was trying to do some research and think about it. Are you aware of any case, at least in modern history, where an opinion like this has been leaked to the public? I couldn't.
No, it's completely unprecedented. The closest example we have in modern history is the leaking of what was already the final opinion in Roe versus Wade some hours before it was officially published. But that opinion was already in stone, and there was no chance it was going to be changed. And so they basically jumped the gun on an opinion that was just about to be published. Even that was outrageous. But this is an opinion which says at the top, first draft. And if it's the first draft back in February, and it hasn't changed since February, because if there were a later draft, the leaker would have leaked that. It looks to me like we have a pretty solid 5-4 majority to overrule Roe versus Wade. And so some fanatic inside the Supreme Court building, it could be a law clerk, but then again, it could be a low-level employee. It could be a secretary. It could be someone in the clerk's office. We don't really know. Decided to leak it in an unprecedented breach of the court's security, which threatens to totally delegitimize Supreme Court deliberations if this is not punished. I mean, if this investigation does not produce a culprit, and that culprit, if he's a law clerk, is not disbarred or prevented from ever becoming the member of a bar, if he hasn't taken the bar yet, then the court has lost its legitimacy. It just becomes a legislative body from which there are leaks. That's all that's involved here. Just another legislative body, and if some disgruntled staffer of the super legislature of 9 super legislators decides that he should leak something to the press, then it gets leaked. So this is what's been happening with the court for decades now, and it began, I would say, in earnest with Roe versus Wade, which invented this right to abortion, laid down this ridiculous trimester framework that, by the way, nobody argued for in the proceedings. Blackmun just invented it, and so we had at that point basically a legislative body. And even critics on the liberal side of the spectrum have said that really this is not a constitutional decision. It's just a
No.
result-oriented outcome involving this judicial invention of a trimester framework, just because the majority wanted abortion to be legal. And so let it be written, so let it be done. The decree of a king or a legislator.
Well, and it's interesting you mentioned that, because I don't know if you've seen, there was a film made a year or two ago called Roe v. Wade, which is really a dramatization of what happened at the Supreme Court during the case. And a lot of people may not know, unless you've seen that the court, actually the members of the court, first voted to not allow abortion. And then there were some wheelie dealings behind the scenes, pressure, some threats made to some of the justices who had conflicts of interest in the case. And they pressured them to revote and call for a argument. And they brought the lawyers back and re-argued again, and then reached the opposite result of their first vote. So it's interesting that abortion was born, to use a pun, in kind of shenanigans and things like this, and then it may be dying in the same way.
Well, let's hope so. I mean, I'm sure they're going to focus on Justices Barrett and Kavanaugh in the hope that either of them or both of them can be induced to change his or her opinion and join some sort of majority with concurring opinions, so there would be no dominant opinion. And the result would be that the Mississippi law would be upheld as just another chipping away at the tottering edifice of Roe. But then the question is, and this was revealed very clearly at oral argument, what exactly are the contours of this right to abortion? Mm-hmm. And the liberal side of the argument is the contours are such that abortion is available at every moment of pregnancy, up to and including the moment of delivery. Because if you don't say that, then you have to get involved in line drawing and find some mysterious point at which abortion becomes not a constitutional right, but a prescribable illegal act. And the oral argument revealed that undertaking is ridiculous. You can't draw such a line. There's nothing in the Constitution that would indicate some arbitrary point during pregnancy at which the imaginary right to abortion ceases to operate. So it's an all or nothing proposition. And everyone recognizes this on both sides of the argument. The liberal side of the argument, the pro-abortion side of the argument was Roe either stands or falls. You can't keep chipping away at it. A 15-week ban, a 12-week ban, a 10-week ban, a 3-week ban, a no-week ban, ultimately, or a ban after conception, or a ban after the heartbeat. How is that a constitutional right? It's obviously an attempt to amend by various forms of state legislation what was, in the first instance, from the court, a legislative enactment. So if you're going to talk about a constitutional right, it either exists or it doesn't. If it exists, and we of course say it doesn't, then right to abortion has to be absolute. And so there would be no arbitrary line drawing. So that's what this opinion stands for, that 98-page opinion basically says we're not dealing with a constitutional right. We're dealing with a judicial creation that has no roots in tradition. And maybe we could talk a little bit about this idea of substantive due process, which Alito basically refuses to apply to this particular case. Maybe the readers would like to know about this idea of substantive due process.
Yes, so it comes from the clause in the Constitution that you cannot be deprived without due process of law, and they've the court, really what Alito I think is admitting, is invented the idea that doesn't just mean you have to have a fair process, but we can just make up some rights that you cannot be deprived of at all, period. That we've just decided. So I found that really interesting. The opinion, as you said, could have been very narrow. It could have been incremental, but Alito seems tripping over himself to just say no half measures will do, a phrase that he actually says in the opinion.
It has to be that way. I mean, either Roe versus Wade stands for a principle as opposed to a result, or it doesn't. And since at oral argument, the liberal side was not able to really articulate a definable principle of constitutional right, it became obvious to everybody, and the liberals won't admit this openly, that Roe had to fall. There's just no other outcome. Otherwise, it's just the case is going to keep coming back to the court to look at different types of bans on abortion. And Alito skewers this idea of the Casey notion, Casey versus Planned Parenthood, of restrictions being allowed as long as they're not an undue burden.
Another
And,
invented
says,
rule. Yeah.
what's due and what's undue?
Right.
This is arbitrary. I mean, one man's undue burden is another man's due burden. It's silly. So what this decision does is say, look, this decision in Roe versus Wade was never anything more than a judicial invention invoking substantive due process. Now, substantive due process, the Liberty Clause of the 14th Amendment applied to the states. As you indicated, it originally was understood to mean they could take away your liberty as long as you had an adequate process, a trial of some kind or a hearing. But the court eventually got around to saying there's a substantive component. It isn't just a process right. It's a substantive right. Now, that might be inoffensive insofar as rights that our tradition recognizes, such as the right to marry. The state can't forbid marriage, for example, and other such rights, such as the right to rear and educate your own children. Those are traditional rights that go all the way back to the time of Moses. They're the hallmarks of Western civilization. If those are the rights you're talking about, which are substantive due process rights, even if they're not enumerated in the Constitution, like the right to religious freedom is, or the right to freedom of speech, well, we could live with that. And even Scalia said, well, we'll live with that if it has roots in tradition. Of course, as we know, that in itself is a somewhat arbitrary historicist standard. Is this a traditional right? Well, what's traditional? So Alito's opinion here is that, well, look, this is an invention. It's about 50 to 60 years old. The common law tradition condemned abortion.
And he actually makes an extensive list of all of the restrictions and condemnations of abortion right up to 1973.
It's a total usurpation by the court. It has no roots in tradition. So if you're going to apply the notion of substantive due process, this is not one of the rights, so-called, that would be found within this penumbra of substantive due process. So the decision is very well done. It's brilliantly written. It totally demolishes the idea that Roe versus Wade has anything whatsoever to do with the Constitution. There's a section there where he shows the different approaches people have taken, the courts have taken with substantive due process, the Fifth Amendment, the Fourth Amendment, the Second Amendment, all being applied. And he concludes that they really can't identify a locus of the right to abortion and a specific provision of the Constitution. So he says sardonically, it's enough for these people that it's somewhere in the Constitution, the right to abortion.
No, it reminds me of the Scarlet Pimpernel. They seek this right here, they seek it there, they seek it everywhere, and they can never find it. Exactly, is what he points out. But it also is interesting. I noticed early in the opinion, because again, he doesn't rule in this draft opinion that there's a right to life, so that the life must be guaranteed by the sovereign state. But just that there's no right to end life, to kill life. But he does actually go to some length to quote a lot of the legislative history in Mississippi for why he said they could rationally conclude abortion should be banned because of various scientific and other evidence proving that there is a life, a separate human life from the mother. And again, I thought even though he didn't go quite so far as to rule that it would be a violation of the constitutional rights of the child, he by introducing that into the argument, I thought was a very telling point.
Well, he says there might not be a right to life, simpliciter, but there's an interest. There's an interest in life, and the fetus has an interest in its own life, and the state has the right to recognize that interest, so-called. But in this book I wrote on the annals of liberty, the modern notion of liberty, I set forth a thought experiment in which the Supreme Court issues an opinion that basically says that there is a right to life secured by the Fifth Amendment, which is incorporated and applied to the states via the 14th Amendment, so that the child in utero has a right to life, which cannot be taken away without due process of law. And the abortion mill does not provide due process of law, so there can't be any abortions. Right. Unless you set up some sort of judicial procedure in which the advocate for the unborn child could advocate for the life of the child, and the mother who wants to kill the child with her lawyer could argue for her right to murder the child in utero. There's no such procedure. And the abortion mill provides no such procedure. So you could simply say that the Fifth Amendment, applied to the states via the 14th Amendment, protects the right to life of the fetus. And since state X doesn't have any procedure, to guarantee that the right to life will be defended in an adversary procedure, then abortion can't be permitted. That would be simple enough. And what's life tenure all about if you can't issue a decision like that?
Exactly. Well, I guess we can wrap up this discussion. We obviously don't know what will happen because we said this was leaked as a draft, and it's not over until it's officially published, which maybe be in the next 6-7 weeks, possibly. Again, I don't know. The fact of this leak, we don't know what it will do. If it'll speed up publication, if it will slow it down, it's just hard to know. But if this were to be issued in the form it is now, where would that take us? Where would be the next fight for defending the unborn? After
Well,
this
obviously, the fight would just descend to the level of the states, and there'd be battles in each state legislature for the legalization of abortion or its prohibition. And then you're going to have liberal states where people will flock to get their abortions, and you're going to have the more conservative states, principally the red states, probably entirely the red states, where abortion is either totally banned or all but totally banned. So, for example, there'd be heartbeat laws and so forth. You know, it occurs to me, though, that there might be something even more effective than a total ban on abortion. And that would be a bill that requires a 72-hour waiting period and a sonogram. Because if you require a sonogram in the southern states, for example, the women who might go to a liberal state to get an abortion, if they see the sonogram, would not, because statistically it's been shown that 80% of the women who see a sonogram of their child, especially when its heart has begun to beat, do not go ahead with the abortion. Which is why sonograms are a key method of preventing abortions. You show the woman that this is not a clump of cells, it's a living human being, it's her child. And that ends it right there. They're overcome. They're overcome with emotion at seeing the living being within them, and they don't proceed to obtain the abortion. So even in the red states, even if they don't enact a total ban, or even if they do, there should be some provision. There's always a provision for health or death, the risk of death if the child is born. Even in the red states, you're going to see that there should be a sonogram requirement and a 72-hour waiting period, and that would effectively end abortions, even if there is a small escape hatch in the red state legislation. Because I don't think any state, even in the red states, has totally banned abortion. Even in the case of so-called threat to the life or health of the mother. So
no, I don't think so.
So in those states, the sonogram measure and the 72-hour waiting period would pretty much end abortions. And
there's we have it. It would return this regulation of abortion back to the states where it was before. History will be returned to where it was, and those will be the next battles. And it can be important, as you point out, the exact wording of how to deal with abortion at a state by state level is a matter which politicians can have some reasonable differences. What's going to be the most effective way to protect the lives of children, and it would be wonderful to see the debate move to that, to have the freedom to move to that level without the 9 legislators imposing their will.
Yeah, I mean, you could be cunning, you could be wise as a serpent. You could say to a woman in a given state, "Oh, you can have your abortion here. There's no need for you to go to Massachusetts. All we ask is that you look at a sonogram and wait 72 hours." They would go. The pro-aborts would go bananas, because the one thing they hate more than a total ban on abortion is sonograms. They do everything in their power to shut down pro-life crisis pregnancy clinics that provide sonograms, because the sonogram is an anti-abortion measure that is extremely efficacious. So we're going to end up with state law battles, including subsidization of abortion using state funds.
Yes.
That's going to be a big issue, taxpayer money being used to fund child murder.
Well, as on our last point, as will be the congressional and senatorial elections in November, because the left's plan to preempt what the Supreme Court does would be to pass some kind of national legislation requiring abortion in all 50 states to once again take away legislative authority from the states. So be very critical that they do not control the 2 branches of government, the Congress and the White House, and and be able to enact something like that, because they've openly said that's their plan.
Well, then the Supreme Court would get that case, and if you still have a conservative majority, they will probably strike it down.
Yeah, hopefully.
Which is why I advocate the more radical approach, which I suggested earlier, that the Supreme Court simply declare, and this would end the issue once and for all, that the Fifth Amendment right to life, incorporated and applied to the states via the 14th Amendment, precludes abortion in the absence of due process of law. There is no due process of law, therefore there is no abortion.
Yes. Well, maybe that's how this will be revised. We can pray. But, well, there you have our two major leaks, one in the Vatican, one in the halls of the Supreme Court, outside of which yesterday there was a group of insurrectionists protesting.
Oh, no, they're just protesters.
Although, actually, they're not getting arrested because the police didn't let them in the building. So they're safe, it seems. But in any event, well, thank you, Chris, for your sage analysis of these stories. And we'll look forward to visiting again in a couple of weeks.
Okay, take care and God bless.